So I know this is the last panel of the day, but I can pretty much promise you that it is going to be the best panel of the day. Sorry, guys, those of you who had led other panels, this one is going to be so much better. And the reason why is because we have the best panel ever. We have Rena Lauji, who is the head of the Office of Financial Sanctions Implementation, which is the regulator responsible for enforcing sanctions in the UK. She's served for 3.5 years. She's actually the inaugural director of this office. She served at other posts within the UK government, including in the Treasury, at the Department of Business, Innovation and Skills, and in the Cabinet Office. We have Andrea Gacki, who is the director of the Office of Foreign Assets Control. She is the woman responsible for enforcing sanctions in the United States. Right here, the UK regulator and the US regulator on one panel. Before joining OFAC, Andrea spent several years at DOJ in the Office of Fed Programs in the Civil Division, which meant that OFAC was her client, and so she was defending them against designation challenges in court. Next to Andrea, we have Dr. Anna, if you're American, Anna, if you're British, Bradshaw. Dr. Bradshaw is a partner on the business crime team at Peters & Peters. She advises both individual and corporate clients on white-collar crime and economic sanctions. She brought the first ever UK judicial review of the implementation of EU sanctions, as well as a number of annulment applications in the EU General Court. And we have Cara, if you're in the UK, you can call her Cara Bombach, who is a shareholder at Greenberg Traurig, where she has deep experience representing individuals and entities before OFAC in delisting matters and challenges to OFAC sanctions. So we have both continents, both jurisdictions, private sector, public sector. We've got it all here, ladies and gentlemen, and you too will have a chance to ask them questions at the end of this panel. My name is Amy Pope. I'm at the law firm called Schillings, which is based here in the UK. I previously served in the White House under President Obama, where we also were responsible for sanctions, but from the other side. So I'm super excited to have this group of people here, and let's get started. So I'm going to set it up, and then I'm going to open it up for them to talk a bit. And we're going to make this a bit conversational. I have a series of questions I have mapped out for them so that they can talk about their enforcement targets, jurisdictional issues, resources, and then talk about mitigation. What happens if your client is sanctioned, is designated, is worried about being sanctioned? And then we'll give you guys some room to ask some questions. So first of all, sanctions enforcement actions are increasing at a consistent rate as government officials and politicians from both sides of the aisle and either side of the ocean recognize how effective it is as a foreign policy tool. The thing that should worry many of you sitting in this room is that this year, OFAC hit an all-time high in terms of total penalties, almost $1.3 billion in penalties. And this year, so far, we're not even about halfway through the year, the total number of settlements now stands at 22, dwarfing all of those issued last year when there were only 7. And by contrast, it's not that, as you can see from this chart, it's not that this was a record year for a number of sanctions enforcement actions. It's that when you look at the last time we had big numbers, for example, in 2009, when there were 27 settlements, the penalties for that year equaled 772 million. So we're now at almost double that for 22 settlement actions. This was led by 2 settlements that were in excess of 600 million each, Standard Chartered and Unicredit Bank. And we're now seeing sanctions, at least from the US, all over the world. This year, the US ramped up pressure on the government of Nicolas Maduro in Venezuela by blacklisting, for example, the country's military counterintelligence agency and state-owned oil giant. They reimposed sanctions on Iran following Mr. Trump's decision to withdraw the US from the 2015 Iran nuclear deal from last year. Some have said that we're moving away from traditional sanctions targets and that they're becoming more diversified. So for example, the Oakland, California-based ELF Cosmetics was fined about $1 million in January for allegedly importing fake eyelash kits from suppliers that had sourced materials from North Korea. We're also seeing a number of extremely large settlements, as I said, the $600 million settlements each from this year. And their big question now is, will this increase? What's ahead for sanctions enforcement? And I'm going to turn it over to the two women who can answer that question right here. So maybe we'll start with, you want to start with Andrea? Okay.
I'll start. Hi, everyone. I don't know if you're familiar with OFAC. The Office of Foreign Assets Control is the part of the U.S. government that enforces and implements U.S. sanctions. Enforcement actions of the type Amy was talking about are just one part of that action. But let me stop and regroup for a second. OFAC has been in existence for about 75 years. And it was created as an initiative during World War II to protect the assets of allied nations in Europe that had been invaded by the Nazis. What would happen is that while these armed invasions had happened, there was a fear that there would be a raid on their reserves in the Federal Reserve Bank in New York. So President Roosevelt, through a stroke of a pen, froze those assets. And that power to freeze assets, which is not the power to seize, established the authority that came to be what OFAC does every day of its mission. And that is, we have civil enforcement authority to freeze assets of a person, which could be an individual or an entity, that is a threat to national security, foreign policy, or economy of the United States. From that power flows many of these actions that we'll be talking about today. As Amy laid out, we've reached, in many ways, an unparalleled level of activity when it comes to sanctions. Sanctions have always been a popular tool across administrations because they are the choice between words and war you'll often hear. But in this administration, in these last 2 years, we've recently taken account of the numbers of designation actions that we put out. And when we put out a designation action, it means we freeze the assets of someone, we block all future transactions with them. That has been, we noted in our recent review of statistics that we are taking a designation action on average every 3.4 days, which is an incredible pace of activity for a very small agency. Actually, we're below 300 at this point. We also, with each action we take every 3.4 or so days, we're averaging 27 targets. Now that statistic is a little out of whack this year because it counts every person that we re-added to these to the OFAC list upon JCPOA snapback when we reimpose sanctions. But it still shows an incredible pace of activity across a number of sanctions programs. You've seen a lot of activity on Iran, on counterterrorism, on Russia, on DPRK, on Syria, on Venezuela. One of our newest programs is Global Magnitsky, targeting serious human rights abuses and corruption. And through that action, taking that designation action and making someone off limits to the U.S. financial system, protecting the U.S. financial system, that in itself is the leverage that we use to then take civil enforcement actions, which were some of the actions that Amy's been talking about, but also the basis for many criminal investigations and criminal cases. Let me pause there and turn it over to Rena.
Thank you. So much younger in terms of being on the sanctions scene. So the Office of Financial Sanctions implementation was set up in 2016 in the UK as part of a government commitment to put more effort into ensuring that we are robustly implementing and enforcing financial sanctions in the UK. So it's not a new set of responsibilities, but is something that definitely there was a political will to do much more about. And in 2016, OFSI was created to carry out to operate as the UK's competent authority for implementing financial sanctions within the UK. So the main difference, and I'll start given where Andrea just set the scene from an OFAC perspective, OFSI doesn't designate. So the decisions on a sort of broader sanctions landscape about who to designate are ones which flow primarily from the UN or from the EU in terms of the sanctions regime. There is one exception, which is primarily around counter-terrorism, where it is a Treasury ministerial decision about who to designate as a terrorist in this context, and to decide on whether there should be a freeze on their assets. And in a similar way, if those kinds of interventions are against international targets, but also UK persons as well, wherever they may be in the world. And in that regard, the point that Andrea just made about the extent to which it is not just about freezing the assets, but also about ensuring that there are sufficient checks and balances and shutting off the UK's financial systems to those individuals and entities who are subject to sanctions becomes really important in our environment, given the significance of London in the financial services market as well. So in 2016, the organisation was created, and one of the innovations that's happened since then has been the introduction of the civil penalties and the power to impose civil penalties in a very similar way. So there it is, whilst we work with the National Crime Agency on criminal prosecutions and support their activities in that realm, we do have the power to impose a financial penalty where we consider that the regulations have been breached, and that power allows us to impose penalties of up to £1 million or 50% of the value of the breach, whichever of the two is greatest. So that came into effect relatively recently compared to the kind of track record that's been going on here. And given the time that cases take to go through our system and that investigative process, it was really earlier on this year, at the start of this year, that we went public with the fact we'd imposed our first two penalties in that regard. But given that the penalty, as those who operate within the UK will be familiar, the legislation was not retrospective, so it is for cases that occurred sort of after the 1st of April in 2017. So that is definitely one of the areas where there is an increasing focus. One of the other areas where indeed it becomes where we engage most with the legal profession is actually in terms of the licensing, where much of the activity that is prohibited under the regulations, you can only do if you're in possession of a license from OFSI, and therefore the provision, for example, of legal services to a designated entity or individual is something that is subject to a license for the payment of that for you to receive payment of that. And therefore, a lot of our engagement is not just through lawyers who are representing designated entities who are sort of revisiting their listings or who are carrying out their activities, but it's actually the advisory function as well as engaging in any sort of strict litigation that's carrying out. And therefore that brings quite a broad range of lawyers operating with a UK nexus into scope for some of the sanctions for the UK. So that's kind of one of the main touch points which may come up through some of the
So hopefully that got your attention, because I think what she just said is that they might sanction lawyers, right? Because is that what
so I think the thing to take away from that is that, actually the legal, what we see in terms of our interactions, there's a huge amount of focus on the banks, and there has been for some time. And it definitely does worry me the extent to which sometimes there is almost amongst some of the lawyers we interact with that there can be an assumption that almost that's not your responsibility, like you don't carry a risk in this realm which needs to be managed. And certainly the provision of services, given that in our system it is an important sort of right that you can access representation. Actually, one of the things that does come into play is that it tends not to be the first thing or possibly even on the list of things that people are considering, that if they are representing or advising a designated entity, that they will need a license in order to be able to get paid for that activity.
So in terms of your enforcement priorities, is it right to say that you're moving away from banks? I mean, there's been a lot of reporting that it's not just banks. And banks have historically been under, everybody knows OFSI and OFAC represent bank or go after banks. But what's next? I mean, are we moving in a different direction? Is that true for OFSI and OFAC? What do you see?
So I don't know. I wouldn't sort of subscribe to the language of us going after the banks, but they obviously would feel very differently, I think, in the way in which that things. Undoubtedly, banks carry a significant amount of risk in this area, and there are the responsibilities that they carry are quite heavy. So I think, given the nature of financial sanctions and the interactions, they will be there in terms of sort of carrying one of the areas with the most risks. But we will deal with the cases that are in front of us. We don't have a sense of, I don't clearly have a sense of sort of here are the sectors that I would like to or I'm intending to impose penalties against. But what I do see is the diversity of the risk that is carried across a number of sectors who, because of the nature of their activity, they have quite serious responsibilities and accountabilities in a sanctions perspective, in the sanctions world.
And I'd like to, add to that. So this past, to Rena's points, this past year, OFAC for the first time, put out a document called a Framework for Sanctions Compliance. And this was novel for us because, and people have told me this, that there was nothing surprising in it. If you know about FCPA compliance, if you're used to principles of AML compliance, the idea of, how you assess risk, having, management buy-in, training, the like, those types of principles didn't surprise people well suited to that compliance arena. But I think the key thing was, and the reason why OFAC had not put out this guidance before, is for many, many years, our principal customers, the people who ingested our list, who screened against it, were banks. And that makes sense. We're part of the Treasury Department. That is our constituency, banks. But our jurisdiction is not limited just to banks. It is limited to all U.S. persons, physical persons, companies. It's also persons who access the U.S. system. That could be using the U.S. financial system. It could be exporting U.S. goods. Because of that, our framework for compliance commitments was pitched to an audience much more broad than the banks. It was consistent, not surprising by design, but also designed to go and reach other constituencies. That's not to suggest that there's a target on the back of non-financial institutions, but it is the case of the 24 cases resolved this past year. I think something on the order of 21 of them are non-financial institutions. I might have that a little off.
Yeah.
And the biggest cases, the Standard Chartered, UniCredit cases Amy referenced, by happenstance, those are big cases that took many, many years to resolve. They were initiated, under the Obama administration, but again, just as part of, making sure banks are being clear, open, giving not stripping, information, not otherwise obfuscating the interest of a sanctions element in transactions routed through the United States. Another interesting case, though, that I'll point out, it's a little bit older. It's from 2017, I think July. OFAC had a settlement with a Singaporean company called CSE Transtel. And that was, I believe, for violations of Iran sanctions. But importantly, in that case is not a foreign subsidiary of a U.S. corporation. Doesn't have U.S. System. What it had done is it had devised procedures to shield its sanctions work from its bank, a U.S.-based bank in Singapore. And that bank reported what they found to us. We didn't go against the bank. We went against the Singaporean entity that was actually obfuscating, using non-transparent practices, and shielding its sanctions work from its U.S. bank. So I think that shows that OFAC does have an appetite to go past, and this is something we've heard from banks for a long time, why are you picking on us? Look at all our clients who are, abusing sanctions. And so OFAC has taken that on and doing a good idea.
Maybe those banks should pipe down.
Maybe that's not good compliance. They didn't say that, but so that's a bit of an overstatement.
And I want to be clear because I did have this chart here that has the Obama administration, Trump administration. When we're talking about who the sanctioned entities are, those are decisions that are made within policy channels. So that's where you're going to get the National Security Council involved, and you'll have different actors weighing in: the Treasury Department, the State Department, the intelligence community, the Justice Department, et cetera. When it comes to enforcement actions, those are not political actions. Those are sort of pretty straightforward. Has this entity violated our sanctions laws? So I just want to make clear that there's sort of different pieces that are sort of interacting here. So Anna and Kara, what are you guys seeing? Do your clients get it? I mean, are you seeing people who are really surprised that they have some sanctions vulnerability here?
Do you want to take a first crack?
Sure.
Yeah.
I can say that particularly in the wake of Brexit, there's a huge amount of uncertainty about what sanctions are, when they apply, how they are engaged, and it's not just UK sanctions and EU sanctions that are creating a problem, but more, given the amount of enforcement activity in the United States, US sanctions, and not just US primary sanctions, but exposure to secondary sanctions that are top of the list for many clients now. And this is likely to continue. We, post-Brexit, have been promised more guidance, and that's to be welcomed. But there is a sense that even with the benefit of guidance, it doesn't necessarily always address the particular problems that we see in practice. And it will be an interesting question to see how easily we can, in the future going forward, get those questions answered by direct engagement with OFSI and other agencies. But it's never going to really make up for the guidance that we really need on secondary sanctions exposure, and the guidance also that we need on the blocking legislation, which at the moment is confined to the EU, but post-Brexit we'll see a UK version of as well. In addition to that uncertainty and the lack of answers, we also see a lot of problems arising for clients who are effectively de-risked or cut off from accessing the not just the banks, but any financial professional services. And I suspect this is a large reason why regulators understandably have focused on the financial sector when it comes to enforcement action, because that indirectly means that the financial sector will then do their job for them in terms of preventing sanctions breaches and sanctions circumvention activity before it even results in an offence. However, that can also go overboard, and what we're seeing as lawyers is this fallout from over enthusiastic de-risking and the inability of companies and individuals to access very basic services and goods. Finally, that brings me to the most basic service of them all, which is access to justice. And it is an important point. Of course, I will make it as a lawyer, but it shouldn't be overlooked, because there is a real risk here. And I think it's been acknowledged for some time that the more aggressive sanctions policy becomes, the more frequent designations become, the more scared lawyers are of crossing that line between legitimate compliance advice and slightly more grey area transactional facilitation advice. The bottom line is that fewer challenges will be brought, and challenges are necessary to ensure that sanctions are not only proved to be completely lawful and in accordance with legal principles, but also perceived to be. And it's that perception of lawfulness that I think is going to be an issue, not just for us here in the UK post-Brexit, but more importantly, for every sanctions enforcement authority in the world. And we see that being raised time and time again now with increasing unilateralism in US sanctions policy and other countries' sanctions policies, and increasing resort to extraterritoriality. And there's no real international law that you can point to and say, this is where the line is, and this is how sanctions policy should develop. And that comes out also at the more granular level when you bring sanctions challenges in the courts, and you have to debate what kind of procedural protections should be available to designated persons, what amount of money is reasonable for them to spend on legal fees, what basic human rights do they have. At the moment, both in the EU and in the UK, evidence that has been relied on in support of a sanctions listing doesn't always have to be disclosed to the applicant challenging the listing, and that's quite a fundamental point to make. So I'll stop there, but those are the key points.
Well, I have sort of a stream of consciousness of comments about a lot of these different points. I think to your original question, from the U.S. side, I think that there's maybe a bit more awareness that the economic sanctions and OFAC regulations apply beyond the banking industry. But of course, that varies greatly with level of sophistication, size of companies, industries. But I would say just from a practice standpoint, we're advising probably 50-50 U.S. companies versus non-U.S. companies. I like to say that OFAC is not industry specific. It's kind of like the FCPA. It doesn't matter if you're selling lipstick or you are running a bank. OFAC sanctions will apply if you meet those sort of jurisdictional touch points that Andrea mentioned. I think that what is surprising to non-financial services clients is just the broad reach of the sanctions, and also the very low threshold for committing violations. So, the prior session on AML, there was a lot of talk about the knowledge standard and intent. And in OFAC land, that really is irrelevant. It's very much a strict liability system. So if you violate the sanctions, you violate the sanctions. It doesn't matter if you knew that you did or not. But I think, and Andrea can correct me if I'm wrong here, but I think that where knowledge becomes relevant is more when we're in the context of a penalties discussion in a settlement action to say, look, we didn't know and we didn't have reason to know. And by the way, here are all these wonderful things about this was our first time offense and we voluntarily disclosed and we have a compliance program and but stuff still happens. So I think that that's a bit of the learning curve, is just understanding what kinds of conduct could create violations. Another eye opener, and again, I feel like this is sort of it's a little related to FCPA in the sense that there doesn't actually need to be a bribe given. It can just be offered. In the sense of OFAC sanctions, there doesn't actually have to be a financial transaction that's consummated if the other jurisdictional elements might be triggered. So a U.S. person providing services, even if they don't get paid for them, to someone in a sanctioned country or who is on a sanctioned list is a violation of the sanctions. So that's another conversation that we have with clients frequently, which is, well, we never got paid, but we issued the purchase order, and but we actually, we did this, or we didn't ship it, we referred it to our affiliate in Morocco. And I said, well, that's not helpful either, because there's a concept called facilitation under the OFAC sanctions, which facilitation is normally, it's like a feel good, like facilitation, I'm helping, this is really useful. But no, from OFAC perspective, facilitation is a really bad word. And one of the types of facilitation is actually business referrals. So a US person who gets a request from a sanctioned country, who says, oh, wait, I had that OFAC sanctions training last year, and I remember I'm not supposed to take orders from Iran, but we've got this affiliate in Morocco. I bet they could fill that order because they're not subject to U.S. sanctions. And so they say, well, I can't fill it, but here, let me give you the contact info for our sister company in Morocco. that is prohibited. That is facilitation of trade with Iran that a U.S. person couldn't do directly. So these are all the kind of outlier things that that I think are still surprising and interesting that we do a lot of educating on. And I think to pick up on Andrew's comment about the OFAC framework that was published in May, I would agree as a practitioner, there was nothing in the framework that was particularly surprising. I do think it's a good read. It's 10 solid pages of OFAC expectations. And these are things that we've been counseling clients for years to say, look, if you are engaged in international trade, if you're providing your service, any kind of cross-border services, you need to have a handle on who you're doing business with overseas, who you're getting paid by, what goods you're dealing with or services. And now we have this nice shiny object from OFAC to point to say, look, we've been telling you, and now you can't say that OFAC didn't tell you what you should be doing. Oh, and by the way, OFAC makes clear in the framework that this doesn't just apply to companies or people that are subject to U.S. jurisdiction. It is expressly stated in the framework that the expectation of OFAC is that even companies that are outside U.S. jurisdiction will have a sanctions compliance program if they have activities that might come into U.S. jurisdiction.
Can we talk about that a little bit? Because this is where I think people really find it difficult to understand where the lines are, right? So a non-EU entity for OFSI purposes, a non-US entity or person for US purposes, can still get into trouble in all sorts of ways. Can you guys talk through, would you, from OFSI's point of view, I don't think OFSI's imposed any penalties on a non-UK company yet. Not to say that I have special knowledge that you're about to, because I don't. Disclaimer. So what are the calculations you're making about whether to do so? And Andrea, within OFAC, when you're looking at a non-US entity, how do you decide whether or not you're going to engage?
So if I start off, so the guidance that we published on civil monetary penalties and the approach that we'll take to that made clear that it is really focused around anybody who is subject to UK law within UK jurisdictions. That's a UK person wherever they are in the world, but also anybody who is operating within the UK. So the fact that the companies that have been subject to penalties so far were kind of operating within the UK, and I think in both instances were registered as part of that framework. So that's where we've set it out, but we stop there.
Sure.
Yeah.
So for example, many of the recent the OFAC actions, the largest OFAC actions in the last 10 years, were for non-U.S. financial institutions where no violations took place, even if they had U.S. operations. And in working that, and then we've expanded to non-U.S. entities. Many of our actions this past year were on foreign subsidiaries of U.S. Companies violating Iran or Cuba sanctions. Those are sanctions programs for which our restrictions also apply to foreign subsidiaries. So we do have an international focus. I will say, practically speaking, those cases have, generally speaking, been settlements. And we've worked sometimes where there's been problems over the years. We've worked with regulators to the extent there is a regulator, usually in the financial system, the home country regulator, to actually partner up and make the action stronger, et cetera. OFAC is not without recourse if it has a non-compliant foreign target violating our sanctions in some way, because if there's a hook for designation, that company may find it may be designated, meaning it's shut out of the U.S. system. Any assets in the United States are blocked. Now, that's just a different tool that OFAC has, that designation of authority and that civil enforcement authority. When you're looking at the use of our civil enforcement authority, keep in mind that 99% of these cases are resolved with no action, cautionary letter. For the most part, we are dealing with people who want to comply, for the most part. And sometimes there have been development of policies specifically to mislead, to obfuscate, to put non-transparent practices in place. But there can be a blending of authorities. And one instance, one granular example, or one, kind of example of this I can point to this past year, happened in a case called Cole Morgan. It's a small enforcement case by OFAC. It was actually a U.S. based company called Cole Morgan that acquired a Turkish subsidiary. The Turkish subsidiary, the U.S. company did everything it could to try to promote sanctions compliance, to put checks in place, to make sure that Turkish subsidiary did not stray from sanctions policies it had set up. And yet there were individuals at work in the Turkish subsidiary that were trying to defeat the policies of the parent, that were setting up other workarounds, denying information. So this came to us through the civil enforcement authority. We were resolving it. We thought that the parent, which takes liability for the actions of its subsidiary, had tried everything it could and yet fell short. So it was actually assessed a fairly minimal penalty in the scheme of things, given the value that was given, I think, was exports to Iran. It was assessed a $14,000 penalty. But contemporaneously with that penalty, we also placed sanctions on the individual who is leading the effort to frustrate the effort of Cole Morgan to promote sanctions compliance throughout its network. And that designation under the Foreign Sanctions Evaders Act served to block his assets in the United States to the extent they exist, prohibit him from engaging in transactions with the United States. So that kind of blending of authorities, that looking at all our tools and choosing how to use them to best handle a situation, I think is a new thing for OFAC and something you should expect to see in the future.
Mm-hmm.
So how often are you guys working together, OFC and OFAC?
So we're in quite regular, our organisations are in quite regular contact. Obviously, we have different legal frameworks, but there are some very common themes that run across both, and a huge amount of consistency in terms of the advice, actually, that we give in terms of what it means to comply with legal obligations. And therefore, we do quite a lot together, both in that realm and also with other jurisdictions.
Yes, absolutely.
So today was not the first day you met. Anna,
So I just had a comment to pick up on Andrea's last comment about the sort of different levers that can be exercised by OFAC. And I think that the designations and the targeting of individuals or entities by adding them to OFAC's list of specially designated nationals is also a tool that is exercised as an alternative. Maybe alternative is not the right word. Recourse when an indictment is not possible in the United States for certain conduct that prosecutors might find problematic. So I don't have scientific basis for this, but my gut reaction is that quite a number of Kingpin Act designations have taken place for conduct where the designee, there's just not enough evidence or nexus to the U.S. For an indictment in the United States. But the basis for an OFAC designation, and correct me if I'm wrong here, Andrea, but I believe that the standard is a reason to believe. So if the OFAC targeting office has reason to believe that someone has engaged in certain conduct, that is a qualifier under whatever the statutory legal authority is for a particular sanctions program, that person or entity could be added to the list of specially designated nationals. So reason to believe is a pretty low standard. And to Anna's point as well, in the US, it's very similar because there is no indictment, there's no criminal information that comes out where we can see exactly what the basis of the designation is. We have a Federal Register notice that says this person is designated for, say, providing material support to XYZ organization or engaging in money laundering activities related to narco trafficking, blah, 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 period. And that is about all the information that there is. So as part of the process for seeking delisting, it's possible to seek the evidentiary memorandum from OFAC, but of course that's going to come back heavily redacted. And so in refuting or attempting to seek delisting, it's a bit of shooting in the dark sometimes. It feels like we're not quite sure what the underlying basis is, but we're gonna go for it. So I think just for this group, I think that's kind of an interesting aspect too, that the designations can be exercised when there's not sufficient grounds for some sort of indictment in the United States.
It's not, so speaking from the other side, it's not necessarily about the indictment, it's
No.
about the kind of evidence, and the kind of evidence that can be used, right?
Yeah.
So when you're deciding whether to designate someone, you're gathering evidence from the intelligence community that you would never normally put into evidence in court.
Right.
You're gathering evidence from Customs and Border Protection or from other law enforcement
yeah.
agencies or from foreign partners or from the team that's responsible for building the case against designees are pulling from far, far greater sources than one would ever pull from when building a criminal prosecution. And that means that it becomes much more difficult to contest that in court. And as Anna pointed out, courts are usually going to defer to the national security interests that the government is going to articulate when defending these. So I think the question for all of you sitting in the office or in this auditorium is, what do I do if I have a client who's about to be designated, has been designated, is concerned about engaging in prohibited transactions? I mean, is it just game over and they're done? So I'll start maybe with Anna, because I know you've contested some of this, and then I'm hoping that I can get Andrea to talk a little bit about the delistings that you guys have seen, and then sort of talk through options. Yeah.
I don't want to come across as bleeding heart here, but
Anna, that's your role. Go for it.
okay.
It's a safe space, sort of.
It's not that safe. It's not that safe, but you're an important voice.
So the biggest difference that you find yourself marveling at as a criminal defense lawyer is when you're acting for a designated person, sanctioned persons, they're not necessarily accused of a crime. There's a small exception to that, at least under the EU sanctions. They're more under US sanctions, where you're acting for people who have been designated under the misappropriation sanctions regimes that were imposed in the wake of the Arab Spring, Libya and Egypt, and then later again in Ukraine. The problem that you find yourself up against there is that you're still treated very, very severely. And when it comes to bringing challenges, sanctions challenges, yes, of course, you can get a license, but it's a long process and it's an administratively burdensome process. And it's one that there is really no way you can short circuit. You have to follow the rules, you have to clearly, but you have to think very long and hard about whether at the end of the day it's actually worth your while, whether it's worth the while of the designated person to go through that process, particularly as if you're challenging EU sanctions, the end result, even if you're successful, may be that, and by the way, the designation will remain in place, even if it's successfully challenged until the period for appeal is expired. And then once it has expired, you can be relisted, but on amended and often expanded grounds. So I think from a practical perspective, you run up against an additional hurdle to the legal hurdle.
Andrea, do you want to talk about delisting and what that looks like? And then maybe you can add into that as well. Yeah.
Sure. And I just wanted to, touch on some points that Anna made about access to justice in the U.S. at least. So, my first introduction to OFAC was as the Justice Department lawyer defending the actions of the agency. So I can appreciate that it's cold comfort, but some comfort that while the designated target doesn't have access to the information, it is reviewed ex parte and in camera by a court in the United States, and that with every designation, there there's a practice of putting an unclassified detailed statement forward as to the basis for the designation. That's often based on the extent to which OFAC can get underlying information declassified. And sometimes it can be so sensitive that facts are limited, but there is that endeavor there. Anyway, just shifting to delisting, notwithstanding those impediments, OFAC is actually facing, maybe because we've taken more actions than ever before, we're also facing a record number of lawsuits. So it has not, actually has not deterred challenges in the United States. Still, so far, we've defended every substantive challenge successfully in the United States, and take a great amount of pride and care in how we put together designation packages. But with the trend of placing more sanctions, more and more sanctions coming out, and going after higher impact targets, one of the issues that I wanted to touch on here is a very notable delisting action that we took this past year. Two major Russian companies, EN Plus and Rusal, designated for the ownership and control interests of Oleg Deripaska, a designated person in the United States. I view this was notable and received a lot of publicity because of a provision in legislation, a new provision that permits congressional review of Russia sanctions-based delisting. Congressional review is not an element of other designations and delistings in the sanctions framework in the United States at this point, really just limited to Russia. Because of Congress's interest in seeing how the administration approaches Russia issues, including Russia sanctions. So that involved a very detailed, very exhaustive negotiations process, much of which was made public, though not all of it. It was made public in a letter that we sent to the Senate Majority Leader and the Speaker of the House, outlining the terms of the settlement. And what it did was, which is notable, and I think worth taking account of, is that OFAC, in agreement for Oleg Deripaska, the designated person, reducing his ownership level, limiting his control, so he could not control the companies. In exchange for that, we have unprecedented transparency and say into the continued operation of these major Russian companies. We are in continued dialogue as we police the terms of removal of these actions, because what happens if the terms of removal are violated is that sanctions could be put back on. So that's also a new thing that OFAC has done. We've always removed sanctions. A healthy sanctions program needs removals as well as listings. But often we haven't seen a delisting of this size, scale, and complexity. And that's what makes this one particularly notable.
And the interesting thing about that one is that it's the first time we've seen, politics injected into the decision in a way that was probably far bigger than anybody really anticipated. And that was partly, I think, because it was coming at a time when there was incredible attention being paid to President Trump's relationships with various figures within the Russian government. And so people perceived it as, well, this is giving a sweetheart deal. But at the same time, what I think has been missing from the public dialogue is that we actually have this situation where a U.S. agency is basically either lifting up the hood or looking under the bonnet, depending which country you're in, of a Russian company, and imposing a level of scrutiny that we would never have anticipated even 10 years ago.
And I've certainly read and heard those suggestions in this delisting process. I see it quite differently, do not see any political motivation in it. But that is the reason why it honestly received as much scrutiny as it did.
Yeah. Rena, what about you? What is it? Game over?
From the broader perspective, if I could just pick up on a couple of the themes that have been raised. So, firstly, to you'd mentioned earlier, Ron, the sort of where the bar is for breaching financial sanctions in the UK, it is reasonable cause to suspect. So, i.e., you don't have to kind of know someone may need not have put it directly in front of you, but if there was reasonable cause for you to suspect it, then that is technically a breach, although as you described, it would be a very similar approach to thinking through then what's the appropriate response to that action. In terms of the designations, counterterrorism is the only sphere in which the UK autonomously imposes sanctions at the moment, and there we do so under primarily, not exclusively. There is an exception where we use some of our other anti-terrorism legislation, but primarily we use the Terrorist Asset Freezing Act, which is one, and actually there the bar is very high. Some argue actually that it is because it's meeting the two limbs of that legislation. Firstly, a reasonable cause to believe that the individuals were engaged in terrorism, but also that it is necessary to impose that asset freeze in order to protect the public. So actually together those limbs actually create quite a high bar. We do have a system whereby we do draw on the intelligence community and wider community in exactly the same ways you might describe to reach some of those decisions. Those decisions are definitely challenged and scrutinised internally. We have an independent reviewer in the UK of all terrorism legislation who spends time looking at the full suite of legislation, including on the Terrorist Asset Freezing Act as well. And I can say this because unlike Andrea, we do lose. Actually, despite that, I'm incredibly proud of the extent to which we have a very transparent legal system, which doesn't have particular deference to the government or the processes, and I think that makes actually for some quite important checks and balances in the system. And as I said, both in those instances where we do get the challenges that come through, and we don't always win some of those challenges. Has been a matter of public record.
Mm-hmm. Do you want to add anything?
Sure. I have a couple more comments on the delisting process. I think that certainly one path to follow is to sue OFAC. That's not usually the first suggestion that I make to a client, partly because of Andrea's track record that she mentioned. But there is an administrative process that I mentioned earlier to seek delisting, and really sort of the cornerstone of the delisting process as it's outlined in the OFAC regulations is that a person who is designated can seek delisting, demonstrating and explaining primarily a change in circumstances. So what has changed since the time of the designation that would make delisting appropriate? So I think for folks that are advising corporates in particular, though this is obviously relevant for individuals who are designated as well, those kind of change in circumstances really tie in with the OFAC framework and the compliance program. So when I'm working with corporates, I'm always thinking about what is your compliance program? What does it look like? What's the basis of allegations? If it's something that is support for or engaging with or something money laundering related, we can kind of go sideways quickly into money laundering investigations, which is not my specialty, but I know people who do it. So we work together, and I know people, and so, that sort of gets kind of into some interesting subject matter crossover, spillover. And the other thing that we're seeing really from a compliance counseling standpoint is I think there is greater awareness now and greater sensitivity for non-U.S. companies who are obviously in even outside the financial services sector, who are very concerned about the potential for OFAC sanctions, OFAC designation, and OFAC targeting for engaging in activities with someone who's on the OFAC list. So, when someone is added to the list of specially designated nationals, and I do believe and I understand that is really the most targeted sanctions approach that the U.S. government can take, and that it's not designed to be punitive, and it's to deter bad conduct. And that it's only targeting assets in the United States, the net effect of an OFAC designation is a global blocking. Because your assets in the United States are frozen, but you're radioactive. Your Swiss accounts are going to get frozen. Your accounts in Hong Kong are going to get frozen. And those authorities are not going to unblock your stuff, sometimes even with a court order, because the banks themselves are so concerned about the risk of OFAC sanctions. So, so I think that there's a sort of a greater sensitivity and need for counseling, which then I think also kind of like brings us back to the original comments about the role of legal service providers and where those lines are for what we're providing as compliance guidance to non-US entities who are trying to understand how to not run afoul of the OFAC sanctions or themselves become the target of sanctions without crossing that line into facilitation or structuring. And so, and I was pleased with, in our sort of like pre-discussion, Andrea started to give a sports analogy, and I'm like, yes, I always give the sports analogy. So as practitioners, we can't tell the client what play to run. But if they tell us, if they throw a pitch, I can tell them if it's foul or fair. So I say, tell me what are the situations, what are the scenarios, and I can tell you under the sanctions whether that's permissible or impermissible and why. And then you can go back to the drawing board and figure out a few of other ways that you can do this, and then come back and I'll, run those past me too. So anyway, I just think it's interesting how all of the things sort of get tangled together.
So we have 15 minutes, and I want to make sure you guys get to ask questions. I have a lot more, so don't feel any pressure. But the back there.
I do have one which is kind of strange. It's under the Helms-Burton Act.
Oh, good. I love Helms-Burton.
Now, US companies can sue companies who have assets or presence in Cuba. So we're getting a lot of U.S. law firms asking us to do investigations in Cuba, basically identify the assets, etc. And a bit of our risk committee said that no, because it would be subject to sanctions by OFAC. Like we would need a special license, and we're sort of in a pickle because there's a case with Iran, the IPSA case, where they got sanctioned for conducting investigations in Iran and paying contractors in Iran and things like that. So wanted to get your take on it. I know it's very specific stuff.
So I think, so this is one of those so Helms-Burton, there are a lot of questions about Helms-Burton. Let me take this one, which I think I can answer. The IPSA case was a pretty unique case because it did involve Iran sanctions, but it involved basically a compliance best practices a company that had sent investigators into Iran when there wasn't an existing authorization for that. There is legal services, but legal services can't be stretched that far. If there is a Cuba's legal services license, it may well not apply for this, but specific licenses in the Cuba context are, very, in all contexts, legal services specific licenses like humanitarian licenses are those types of licenses that we actually will act on fairly quickly. We've got some blueprints for it. I will say that, and so I don't know the exact circumstances of your situation. You might want to explore that if the Cuba general license for legal services doesn't apply. But anyway, let me stop there.
Apparently, we have some really good lawyers who advise you. Go ahead. In the back there, yeah.
It's a question for Andrea. I'm a UK lawyer, so forgive my ignorance of US law. And I think I may make a number of assumptions in the question, which you will correct me if I've got them wrong. It's about the Magnitsky. As I understand it, under the Magnitsky Act, in a sense of complaint is brought both by a house committee, for example, but also an NGO where there's suspicion of gross human rights violations being committed by an individual. First of all, am I sort of broadly right about that? And secondly, can NGOs or even individuals or collections of individuals bring complaints against a person who says you need to sanction this person because they're up to no good?
So I apologize because I don't know the exact text of the Magnitsky Act, but I can tell you on a very routine basis that we develop cases based on robust input from NGOs, civil society, for cases under the Magnitsky Act, but also its companion, Global Magnitsky. For example, We took 2 actions last week on corruption targets in South Sudan and in South Africa. Many NGOs had actually done investigations, given us information. So the exact information in the Magnitsky Act itself, I'm not sure of. I'll need to look that up. But absolutely, information is received, and in fact, the Congress will deliver information and recommendations to us as to how to apply that authority. Magnitsky is based in Russia focused, and global Magnitsky is it's basically
Broader
non-US.
than Russia.
Yeah.
John?
Hopefully.
Yeah, I have one back question, one question. Just very quickly, when you go ex parte for your designation, and you explain that there is a judicial function, do you have the same duties of absolute candour that you would have in equivalent situations in the UK? Because, I mean, from the point of view of the other side, it's a fairly Kafka-esque scenario that we're looking at here, where there's no real adequate challenge to sanctions and no easy route. So what is OFAC's obligation to the judge when you go into that ex parte process, and how is that defined?
So in my experience, and I did face this as a lawyer at the Department of Justice, is we do have all the ethical standards of a lawyer conducting proceedings before a U.S. court, to include candor and any other requirements would attach. What there is there's the introduction of the classified record, which the judge reviews. We owe, if the judge has any questions, we are obligated to answer them. It is a record review case. So the judge will look at, under the basis of the Administrative Procedure Act, will assess it as to whether or not the agency acted arbitrarily and capriciously. That's our standard. And that's where the reasonable basis to believe is drawn from, is from the APA standard. Different from criminal, and the penalties are different. They're strong, they're powerful, and they have to be applied with care. I'm not saying, but it is not a criminal standard.
Yeah.
I mean, very quickly.
Yeah.
You've explained the situation as it currently stands when we sit ultimately within the EU
Yes, I was
environment.
waiting for this
What
question.
happens on the 1st of November?
Tell us 5
If you
minutes.
confront it
Well, the
as,
1st of November means we keep going.
We have a new act in place, so what's obviously planned, because you've gone through 3 years of education, you're now in an enforcement scenario, so where do you see that future?
So our sort of obligations, as I see them, to raise awareness and ensure that people understand their obligations isn't something that we have kind of started and finished. It is an ongoing and living process. And with that in mind, we have obviously been engaging in a discussion about the guidance for a post-Brexit scenario, in particular when the new legislation comes into effect and we start to impose sanctions in that realm. And we've done some consultation around that guidance and then intend to publish that in a draft format. So in that sense, clearly, once we end up in a situation where the UK is operating autonomously, there will need to be a renewed focus from our perspective to really think about how we ensure that there is an awareness about it, and particularly if we're in a circumstance where, well, I mean, in any regard at the moment, companies are having to comply with multiple sets of regulations, and that will still be the case going forward. So, don't ask me what's going to happen and when it's going to happen, but what I can say is that the implementation function that we have continues on, and we are ready to be able to implement in those circumstances.
In the back there?
Can I just ask, in relation to OFC, some publicity recently has suggested that there's about to be an announcement of very large enforcement action in relation to the fact that you're in the can we expect to see further enforcement in the near future?
So I think we can expect to do that. My teams are working day in, day out on on some of the cases that are coming through the pipeline. I don't comment, we don't comment on those cases that are going through that process, not least because it is right that we not just ensure that we are following our processes in all instances, but also that companies who we believe have breached financial sanctions, or individuals that we believe have breached financial sanctions, have the opportunity to make the necessary representations and to do that in a way which doesn't have any unintended consequences. And therefore we don't kind of include any information until we're right at the end of the process.
Anything else? All right. Well, so maybe before we conclude, I'm just going to have these guys, since we have 6 minutes left, I'm just going to have these guys kind of wrap with their sort of key issues that they want you to walk away with from this amazing panel, probably the best you've ever been to. Why don't we start with Kara and then we'll go down?
Gosh, not prepared for that. Takeaways, OFAC, sanctions, not going anywhere. And I think the big takeaway from the OFAC framework that I am preaching now is it's time to do your OFAC risk assessments, your economic sanctions risk assessments. If you have not done, or your clients are wondering, I've heard about this framework, what do I do about it? A good place to start would be to think about doing a sanctions risk assessment. And without boiling the ocean, let's make it global, not just US focused. Let's think about where the company is operating and where the risks are.
So takeaways, from my perspective, I started with uncertainties. I think the main two obvious uncertainties in the post-Brexit legislation are going to revolve around the concept of ownership and control, which is going to change in ways that we don't fully quite understand yet, but no doubt we'll get more guidance on in due course. And also how EU sanctions that are going to be retained in UK law post-Brexit are going to be translated or interpreted in very different circumstances. And the big one for practitioners are the sectoral sanctions against Russia, where you have majority-owned non-EU or non-UK now subsidiaries that attract the sectoral sanctions. But in addition to that uncertainty, which will create lots of lovely work for us lawyers, hopefully, we also have the new opportunities for bringing legal challenges. And it's going to be interesting to see how that pans out, because I understand there is a very great willingness on the part of obviously another government institutions to ensure that those challenges are dealt with appropriately. But it is quite an interesting hurdle in the beginning, because you have to first, before you get to go to court, pursue an administrative challenge. You have to ask a government minister to reconsider the designation decision, and there's no time limit for that. And then once you get a view back, and this only applies if the designation is a non-UN designation. If it's a non-UN designation and you get an unfavorable position, you can then go to court. You can ask the High Court to consider the claim on judicial review principles, but the right to receive damages is, surprise, surprise, in the wake of the Bank Mellat saga, restricted to instances where you can prove negligence or bad faith. But even with those hurdles, I think as a lawyer, I'm quietly optimistic that the English courts will be more robust in removing individuals and entities from lists or designations when it's appropriate to do so. And that raises quite interesting questions about forum shopping, because if you have an individual and an entity, more often than not, they'll be subject to EU sanctions as well as UK sanctions, or even also US sanctions. And if the UK court is prepared to find that they should be removed from a list, then that's going to unleash quite a few layers of really complex questions.
So main takeaways, I will just say that I think sanctions remain incredibly popular. and they're growing more powerful, more complex, and we haven't reached a tipping point where I see any ebb in the pace of sanctions activities. But along with that, I think you've seen OFAC issue guidance, deal with issues in novel ways, in a way to mitigate the consequences of those sanctions. So takeaways is I would, when facing a sanctions issue, honestly, don't hesitate to reach out to OFAC. We are informed by input that we receive, and make decisions on a fairly nimble basis for a government agency to adapt to circumstances.
Rena, the last word.
So the first point, just obviously picking up on the theme around Brexit. Obviously, these are uncertain times. I recognise the kind of uncertainty that and it resonates with me definitely. But the government has in this area put in place all of the systems, the legislation, and the structures in order to be able to manage to impose and to implement financial sanctions on and kind of independent and autonomous basis, and we remain committed to, within that realm, publishing guidance and continuing to engage with the private sector around to make sure that there is an understanding of what it means to comply with the regulations if you are operating within a UK jurisdiction, but also then to make sure that we are enforcing them as we go through and where we see the breaches. The second takeaway that I would probably focus on is actually the theme that has run through around which sectors and who, and is this just about the banks, because we've naturally spoken a lot about the banks and about law firms for obvious reasons in the audience. But actually for us, there is a big theme around some of the other sectors, in particular the charities and NGOs who are operating. We've seen a number of cases. Obviously, they are, and we have developed some specific guidance in the past around that, because they are usually operating in some of the most difficult circumstances, and particularly where the sanctions by are very keen to support them in understanding their obligations, but also around smaller companies as well, where some of the more established due diligence processes that we've been discussing this afternoon aren't in place, and working to make sure that where they are in an exporting community, or indeed have particular touch points from the trade that they do or the countries that they operate with, where they have significant exposure, to make sure that there is a greater awareness and less of an assumption that you can sort of outsource the management of that risk to either your bank or your lawyers in those circumstances. So that would be the same.
That's great. So please join me in thanking this incredible group of women for their time, their expertise, and their